This is Bloomberg Law with June Grasso from Bloomberg Radio.
Louisiana's law requiring the 10 Commandments be displayed in public school classrooms is making its way up to the Supreme Court. The constitutionality of the law is now before the U.S. Court of Appeals for the Fifth Circuit after a federal judge said the requirement violated the First Amendment. The case has implications outside Louisiana, as lawmakers in other state houses have begun to propose similar laws. Joining me is First Amendment expert Caroline Mala Corbin, a professor at the University of Miami Law School. Caroline, explain why the lower court blocked this Louisiana law.
So this all started when Louisiana passed a law mandating that every single public school classroom in Louisiana, from kindergarten through high school through college, post a King James version of the Ten Commandments. And naturally, this was challenged as violating the Establishment Clause. That's the clause in the First Amendment of the U.S. Constitution that mandates some degree of separation of church and state. And lawsuits start in district court. And in some ways, this was a really easy decision for the district court because the U.S. Supreme Court had addressed a very similar statute 45 years ago. 45 years ago, Kentucky had passed a law that mandated every single public school classroom post the Ten Commandments, and the U.S. Supreme Court said this violates the Establishment Clause. It's completely unconstitutional. There's no secular reason to have Ten Commandment text in public schools, and laws passed by governments have to have a primarily secular reason. Otherwise, if it's a primarily religious reason, that's getting a bit like a theocracy. And so when the case came before the district court, it had a precedent from the Supreme Court directly on point that held that laws mandating 10 Commandments in public school classrooms violates the Establishment Clause. Did
the Supreme Court in 1982, did they change the test that they had used in that case?
So here's what's going on. Since 1980, when this decision was made, we have a very different Supreme Court, and we have very different Supreme Court rules. And that's what Louisiana has banking on. Because at the time the first case was decided, there was particular doctrine that controlled the test that's known as a lemon test. Now, the current Supreme Court has jettisoned that test. And it said the way we're going to decide whether something violates separation church and state is we're going to look at history and tradition. And history and tradition is highly manipulable and very contested. But Louisiana is probably banking on the Supreme Court's willingness to sort of construct a history and uncover tradition that would support 10 Commandments in public schools. So the answer is the doctrine has changed, court has changed. We currently have a court that is much more receptive to Christianity in public schools, and it's not at all clear what it's going to do when it revisits this case.
Louisiana said that the law was passed to teach students about the Ten Commandments' importance to the American legal system. That was one of their arguments.
They had many arguments, yes. So there are lots of different strategies that you can use when accused of violating the Establishment Clause. And one of them, and I just finished a paper sort of addressing precisely this question, so I'm delighted that you're having me on to talk about it. So one of these strategies is what I am calling secular washing. And that's when something that is inherently religious symbol, inherently religious text, like a giant Latin cross, or the Ten Commandments from the Holy Bible, is recharacterized as something that's actually secular. And so one of the things that Louisiana is trying to do is argue that these Ten Commandments, this is not religion, this is history. It's just history. And therefore, it's not really problematic at all under the Establishment Clause. It's not even about religion, so what's all the fuss? It's about the history of our country, the importance of the Ten Commandments to our law, and the importance of the Ten Commandments to our values. This is, again, the bottom line with secular washing is trying to recharacterize something that is obviously religious, but to claim that, no, it's not really, it's actually secular if you truly understood what it was all about.
The attorney for the challengers tried to stress the religious intent of the law's author, who he quoted as saying, "It's so important that our children learn what God says is right and what he says is wrong."
Yeah, the claim that this is about history is ridiculous. It's clearly about trying to reintroduce Christianity into the public schools. And the sponsors themselves, as you started to cite, are not really hiding the fact. The litigators might be trying to cover up the religious motivation behind the law. But the sponsors were quite clear it was about making sure children understood God's words.
How does Louisiana defend against the fact that there are references to God and the Sabbath in the first 4 commandments?
The first 5 commandments, they're all religious. I am your God. You shall have no other God. You shall not take my name in vain. You should observe the Sabbath. Right? The first 5 are religious commandments. There's absolutely nothing secular about them. And even the others are not altogether secular. Honor thy mother and father, but it's ultimately a religious obligation. It's kind of a hard argument to make that this is not religious. I mean, it is from the Holy Bible. But again, what Louisiana is banking on is that the Supreme Court is not going to analyze whether it's religious or not. What instead it's going to do is ask, is there a history and tradition of 10 Commandments in public schools? And if there is, then we're going to find it constitutional, because that's the new test the Roberts Court has created for challenges like these. The question is this a long-standing religious practice? If it is, we're going to find it constitutional.
Well, I mean, is there a history of having the 10 Commandments in public schools?
So the answer is no, and definitely no. Another tactic, again, there are lots of strategies that courts use. Part of the challenge when you're trying to decide whether a practice is deeply rooted in our history, whether there's a long-standing tradition of a particular practice, is how you define the practice. Like, defining the practice is really key. And the state of Louisiana is trying to define the practice as any appearance of the 10 Commandments in public schools. Although the more accurate is there a long history? Is there a practice of posting 10 Commandment posters in public schools? And that matters. That matters because the Supreme Court has never completely banned the Bible or the 10 Commandments from public schools. It is entirely constitutional to talk about the 10 Commandments in a secular course of study. So if you're studying literature, for example, absolutely you could study the King James Bible, which is a masterpiece of writing. Or if you're in a world histories class, obviously you can compare and contrast the holy commandments of different religions. But the thing you're not supposed to be able to do is to proselytize or preach or try and teach religious tenets as the true word of God. That is what is forbidden in class. So it's neither here nor there if people have studied the 10 Commandments in class in public school before. The question is, have they posted 10 Commandments on the walls as a way of bringing children closer to God? That's the real question. And the answer to that question is absolutely not. There is no history of any such thing. One of the things that the district court did was listen to an expert on this exact subject testify about the history of religion in early common schools up through today. And he said, absolutely, there is no history whatsoever of 10 Commandment displays in public school. And Louisiana hasn't offered any evidence either. Again, the test is there a history and tradition of this particular practice? This particular practice, Ten Commandments posters? The answer is no, and Louisiana has no evidence otherwise.
This is expected to go to the Supreme Court. Do you think that this posting of the Ten Commandments goes even too far for this court, which favors religion in almost every case it comes up in?
I don't know. I really don't. This court seems to have been welcoming religion into all areas of the government where it has previously been unconstitutional. It looks like it's about to remake Establishment Clause doctrine when it comes to funding religion. Again, this is a court that upheld a giant Latin cross, a government Latin cross monument, as perfectly constitutional. This is a court that has held that a coach on duty may pray in the middle of football fields immediately after games in front of his students, despite 3 prior Establishment Clause decisions suggesting that's not constitutional. So I don't know where the Supreme Court draws the line, and I have no confidence that it's going to draw the line here. Now, I sure hope I'm wrong, but I can't confidently say one way or the other.
I mean, it seemed like this Fifth Circuit panel, which was one Reagan appointee, one Clinton appointee, and one Obama appointee, seemed pretty critical of Louisiana's position.
It's blatantly unconstitutional under any test, and certainly under Supreme Court precedent that has not yet been overruled. It's obviously unconstitutional. There's no question that it's unconstitutional. I mean, and again, to the extent that Louisiana tried to create a history and tradition of Ten Commandments in public schools, its proof was really weak. I mean, part of their proof was a quotation from James Madison that they just made up.
What quote was that?
Here is the quotation in the legislative history. History records that James Madison, the 4th President of the United States, stated that we have staked the whole future of our new nation upon the capacity of each of ourselves to govern ourselves according to the moral principles of the Ten Commandments. He never said that. They have been called on that. And again, they have been trying to construct a history and tradition for the Supreme Court of Ten Commandments in public schools. The best they can come up with are 3 different textbooks that included it. So they have no history of actual displays or posters, just textbooks that might have included the Ten Commandments. And that's really the extent of it. And of course, one of them existed before the country was formed and was used in the colonies, which is not really very informative. And it was also virulently anti-Catholic, right? So part of their history is relying on Protestant practices that reflect virulent anti-Catholicism, which in other contexts, the court has said we will not find this history dispositive in our constitutional inquiry.
Their argument that the controversy, it wasn't ripe and the challengers don't have standing?
I mean, again, a common tactic for trying to judge an Establishment Clause violation, in addition to secular washing, is to claim that the plaintiffs don't have standing. That is, in this case, they're saying it's too early to bring this claim. It hasn't actually been put into effect yet. So more specifically, they're saying it's brought too early. The legal term is unripe. It's not ripe. There's not enough of a record. But frankly, you don't need any more information than is already present to decide whether it's unconstitutional or not. They're clearly hoping that this will be a vehicle for the Supreme Court to overrule its prior precedent, holding you can't foist Christian dogma onto public school students. They're trying to overrule the prior case. And so the question will be, will the Roberts Court take this invitation and happily overrule prior precedent and allow religion into the public schools? And not just religion, Christianity. because these are Christian 10 Commandments.
And even Christianity, I mean, it's the St. James Version.
Exactly, right? People say, oh, but Jews have the 10 Commandments. Yes, they do, but their 10 Commandments are different than the ones posted. And the Catholic 10 Commandments are also different. So not only is the 10 Commandments favoring Christianity, it's favoring one branch of Christianity over others. And if the Establishment Clause means anything, it's that the government can't favor some religions over others. And that is inevitably what happens when a school posts the 10 Commandments in its classrooms.
It'll be interesting to see how this Fifth Circuit panel with 2 Democratic appointees on it rules in this case. Thanks so much, Caroline. That's Professor Caroline Mala Corbin of the University of Miami Law School. Coming up next, Trump lays the groundwork for a sweeping anti-climate agenda. I'm June Grasso, and you're listening to Bloomberg. In the dizzying number of executive orders President Donald Trump signed on day one were a series of orders laying the groundwork for a sweeping overhaul of U.S. energy policy, putting the weight of the federal government behind fossil fuel production and pulling back from the fight against climate change. Trump insists his Drill Baby Drill program will bring down prices and inflation.
It just works that way. I mean, it just economically works that way. When the oil comes down, it'll bring down prices. Then you won't have inflation, and then the interest rates will come down.
My guest is an expert in environmental law, Pat Parenteau, a professor at the Vermont Law Graduate School. Let's start. Trump declared a national energy emergency on day one. What does that allow him to do?
Well, a declaration of a national emergency just generally does, quote, unlock certain provisions of federal law, but it's a statute by statute kind of thing. The declaration itself doesn't do anything. It's a predicate for what's to come next. So now you have to go through individual statutes. For example, offshore oil and gas leasing. That's governed by the Outer Continental Shelf Lands Act. If it's an on-land oil and gas development, the drill baby drill mantra, that's governed by a law known as the Federal Land Policy and Management Act, and so on and so forth. So the orders themselves are a clarion call, right? And a policy announcement, clearly, and a direction that the administration is going to go. But legally, it's going to go statute by statute, and in fact, project by project, whether you're talking about a gas pipeline or an oil pipeline or an LNG terminal or whatever. It's going to go, project by project, law by law.
He also ordered quarterly meetings of a committee of cabinet-level officials known as the God Squad. What is the God Squad? They've only met a handful of times over the past 4 decades.
Right, and I've been the only lawyer who has appeared in all 4 of the God Squad proceedings. So you're talking to the guy.
I don't know if that's good or bad. I'm trying to figure that out.
I don't know. I can tell you this. The Endangered Species Committee is not a standing committee, okay? It doesn't meet quarterly or regularly at all. In fact, it can only meet as the Endangered Species Committee when there is an application in front of it that meets really specific statutory criteria that I had a hand in drafting. And the most basic one is there can be no exemption process unless there's what's called an irreconcilable conflict between a specific project, maybe it's a water project, a highway project, timber sale project, but there has to be a really specific project, federally authorized or undertaken, and it then has to conflict with the commands under Section 7 of the Endangered Species Act, meaning the activity in question has to jeopardize, that's the term, the continued survival of a listed species, endangered or threatened, right? So we don't have anything like that. As you point out, there hasn't been one since the Spotted Owl God Squad proceeding where I was the owl's lawyer, if you will, because I was the special counsel appointed to the Fish and Wildlife Service to present the case for preserving the owl's habitat to the God Squad. So there hasn't been one since 1992, is my point. And there is nothing on the horizon that would give rise to convening the God Squad.
Pat, I wish I could say I was once the spotted owl's lawyer. That's so, really, saving an endangered species is a higher calling in my book. Back to the executive orders now. So Trump is trying to speed up project reviews using emergency consultations under the Endangered Species Act, which is usually reserved for natural disasters. And Noah Greenwald, he's the Endangered Species Program Director of the Center for Biological Diversity, said this executive order is a death warrant for polar bears, lesser prairie chickens, whooping cranes, and so many more species on the brink of extinction. Is he right?
Well, I love Noah, but I wouldn't go so far as to say it's a death warrant, okay? It's a threat from this administration to use the exemption process and the accelerated consultation process to speed up fossil fuel development. But here's the thing. Again, there's law that has to be followed. You don't just wave your arms and sign a piece of paper calling it an order and then, start building stuff. That's not the way it works. So if, in fact, the Secretary of Interior, the Secretary of the Department of Energy, or some other cabinet official starts authorizing projects that conflict with the Endangered Species Act, that don't go through the full formal consultation process, I'm sure that the Centers for Biological Diversity will be the first one to file a lawsuit. And they're going to win. Because here's the thing. The emergency consultation procedures are triggered by disasters that threaten human life and property. Where is that happening? Well, it's happening in California, for sure, but it's not the result of the Endangered Species Act. Here comes the, punchline. It's climate, stupid. So that's what's threatening natural disasters right now. It's not water management in California. It's climate change, accelerating and exacerbating the wildfire problems that California has always had. So I'm not ready to say that just because Trump issued an order, species are going to go extinct. Not without a hell of a fight, anyway.
Pat, is he trying to blame the water crisis in California on that little fish?
Yes, he is, although the Delta smelt, he's called the Delta smelt out. The Delta smelt, by the way, now exists in captivity. It's functionally extinct in the wild. That's happened with other species like the California condor, the black-footed ferret. There's a number of species that have gotten to the point where they had to be taken into captive breeding programs and then reintroduced into the wild. That's the case with the Delta smelt. But here's the other thing. There are 5 species of fish, including 2 species of salmon, which are recreationally, commercially valuable and also valuable to the tribes in California. So there are 5 different species involved in the San Joaquin Delta where the Delta smelt habitat exists. So it isn't one species, it's a whole suite. In fact, it's the whole ecosystem of the San Joaquin Delta that's at risk here.
One promise he made repeatedly during the campaign was drill, baby, drill. That's his policy. And in his inaugural address, he said, "We will be a rich nation again. And it is that liquid gold under our feet that will help."
Right. So here's the facts. That's a fact-free statement, right? So the fact is, the United States is the largest producer and exporter of oil and gas on the planet. And oil and gas development, contrary to a lot of climate activists, tremendously, exponentially expanded under Biden in the last 4 years. So, A, there is no energy emergency. B, as to drill, baby, drill, here's the data. 25 million acres of federal lands, on land oil and gas, are under lease already, not being developed. 25 million acres of public land. Secondly, there are 9,000 drilling permits that have been issued. They're not being developed either. Why not? Because there's a glut of oil and gas on the market. Why are gasoline prices at the pump the lowest they've been in 70 years? You heard that right, 70 years. Go back and look it up. Not since the 1950s have we seen prices this low at the pump. The reason is there is a glut of oil and gas on the market right now. That could change, of course. But as of right now, there's no basis to declare an energy emergency. There certainly is a climate emergency, or if you want to look at it another way, the real energy emergency is the failure to convert and transition away from fossil fuels and to the cleaner sources of energy, solar, wind, which of course Trump hates because it interferes with his golf course in Scotland. But beyond that, where is most of the renewable energy being developed right now? In Republican states. Texas, Oklahoma, Iowa, and so forth. So the real emergency is we need to get on with the business of transitioning to cleaner, more efficient, and actually more profitable sources of energy.
So as you mentioned, he's been vocal about his dislike of wind for years. What is he trying to do with these executive orders and alternative energy like solar and wind?
He's put a pause, as he put it, on offshore wind projects that are still in the permit process. There are 9 of them that have already received their permits, and they aren't caught by the executive order, but there are 7 others that are not finished with permitting. And so he's put a pause on them, and he's threatened to withdraw major portions of offshore wind areas, particularly in what he calls the Gulf of America, which the rest of the world still calls the Gulf of Mexico. And that's a problem or an issue that's going to have to go to the courts because, once again, the president does have authority to withdraw areas of the ocean from development, including, I would acknowledge, wind development. But again, there's a process by which you do that, including doing an environmental assessment and changing the leasing programs that already have been approved and so forth. So as to further development offshore, that'll be a subject of litigation as well. Here's the downside to all this is it is going to discourage investment. There's been a lot of interest from European Union nations like Norway and Denmark, which have pioneered a lot of offshore wind, and they want to invest hundreds of millions of dollars in offshore wind in the United States waters. But of course, this particular period of time would probably discourage that kind of investment. So even though the orders may lack some legal foundation, they probably will have the desired effect of discouraging at least rapid development of wind, and in some cases probably solar as well.
Citigroup analysts have said that Trump's policies won't stop the transition to green energy, citing its economic viability and technological innovation. So in 4 years, how much damage do you think he can do to the advancement of clean energy?
Through these orders and decisions and changes in rules and rollbacks of environmental rules, I think he's going to get tripped up repeatedly in court on those actions. But I do think we're losing an awful lot of momentum and opportunity. I do think there's going to be a discouraging effect on the investment market for the next 4 years that may take longer than that to rebound. And certainly as he drives more and more people away from federal service, which he's intent on doing, that's going to have an institutional impact on our ability to recover from these 4 years and get back into the game of transitioning to renewable energy and cleaner energy sources, including electric vehicles, all of which the marketplace is pushing. So I would agree with the comment that he can't stop the transition that's underway. He will certainly slow it down.
Stay with me, Pat. Coming up next on the Bloomberg Law Show, I'll continue this conversation with Professor Pat Parenteau of the Vermont Law Graduate School. We'll talk about Trump's reversing course on electric vehicles, rescinding environmental justice initiatives, and dropping out of the Paris Accords for the second time. I'm June Grasso, and you're listening to Bloomberg. On day one, President Donald Trump signed a series of executive orders laying the groundwork for a sweeping overhaul of U.S. energy policy, putting the weight of the federal government behind fossil fuel production and pulling it back from the fight against climate change. I've been talking to environmental law expert Pat Parenteau, a professor at the Vermont Law Graduate School. You mentioned electric vehicles. He's reversing course on electric vehicles. What were the rules on electric vehicles in the Biden administration?
So there are 2 of them. There's one called the tailpipe rule, which regulates tailpipe pollution from automobiles primarily under the Clean Air Act. And the other one is the fuel economy rule, that the Department of Transportation, through the National Highway Transportation Safety Administration, or NHTSA, as it's called, adopts. These are the CAFE, the corporate average fuel economy standards that get promulgated every few years, right? So both EPA under Biden and NHTSA under Biden adopted strong tailpipe and fuel efficiency rules. They don't, quote, mandate electric vehicles. They do anticipate that the standards put in place will move more of the automotive fleet in the United States towards electric vehicles and plug-in hybrids. And in fact, it's really the plug-in hybrid market, the one that's the most promising and the most robust right now, because a lot of people, and myself included, have, electric vehicles that have very limited range capacity because there aren't enough charging stations. That was another thing the Biden administration was investing billions in building out charging stations across the country. And I'm sure we're going to see both Trump and probably the Republican Congress cutting back on some of those investments as well, all of which is not good news for, a rapid uptake, as they say, of electric vehicles. But it isn't going to stop electric vehicles. Large auto manufacturers like Ford and others have actually supported these really strong measures on tailpipe standards and fuel economy. They see what's happening with the innovative technologies that are being spurred, frankly, by countries like China, which is building electric vehicles left and right. China is also the largest producer of solar panels in the world. So we're ceding economic development to China with these policies and orders that are coming out of the White House. We're not advancing America first. We're not advancing America dominance. We're going in the opposite direction of where the market is going.
This is no surprise. He's rescinding environmental justice initiatives. So there are nearly 80 Biden administration initiatives. So what kind of damage does this do?
This is terrible. This is another part of what we're seeing out of this administration is outright cruelty to people. There's no question but what Black, brown, and low-income communities across the country have for decades been subject to disproportionate health and environmental impacts. That's where all the really hazardous facilities are cited, whether it's dumping grounds for toxic chemicals and toxic waste, or whether it's oil refineries, whatever it is, Cancer Alley in Louisiana, for example. These are communities that have suffered from disproportionate environmental impacts for decades. And finally, we had an administration who took seriously the ethical and the moral obligation to stop that and to bring attention to bear on, places where people are getting elevated levels of cancer, dying prematurely, having miscarriages, and all kinds of really serious health and well-being impacts. And the truth is that we have not devoted enough time through environmental law, through permitting and licensing, to avoid burdening these communities with ever more life-threatening, health-threatening activities, and also creating the enforcement capability to target those areas where people are dying and getting sick, and bringing enforcement actions through EPA and the Department of Justice to clean it up and to stop it and to protect people. We've also seen last week that Trump has ordered all five of the section chiefs in the Department of Justice that are in charge of the environmental enforcement sections of justice. He's reassigned them to immigration. I don't know exactly what they're going to be doing on immigration. They're environmental lawyers. They're the lawyers that are leading the effort in the United States to keep communities safe, to bring polluters to justice. And he's decimating the capability of these agencies to do that. That's the real harm that we're seeing.
His administration has stopped all pending environmental litigation that includes pending settlements and consent decrees. But aren't they going to need environmental lawyers to be fighting all the lawsuits that are going to come down because of these executive orders?
Well, that's the irony of what's going on here. By taking out senior career professionals in the federal agencies, it's actually going to make what Trump wants to do even harder to do. It'll mean that instead of carefully following the law, crossing the T's, dotting the I's, and all of that, they're going to keep making the kinds of mistakes they did in the first round in Trump's first administration. In their hurry to do this, in the demand or to be loyal to the president, not loyal to the rule of law, they're going to make all kinds of mistakes. But here's the problem. It takes time to chase down all these things. That's another strategy here is, flood the zone, throw so many things out there that people will be dispersed and can't keep up with everything he's doing, can't get all these cases into court and get them heard, get them reversed. That's what they're counting on, I think, is just do so much that some stuff is just going to go through because there isn't enough opposition on the other side and there isn't enough time to get them all turned around or overturned, right? So eventually, I think you're going to see that happening. It'll be later in the 4 years, but, apparently the strategy is stop us if you can.
So he rescinds Biden rules. Do most of the things he wants to do require federal rulemaking?
Yeah, the big things do. The tailpipe rule, the power plant rule, the methane rule, a lot of the rules under the Clean Air Act and Clean Water Act that Biden adopted, and the Endangered Species Act and the National Environmental Policy Act. All of those rules that are on the books are going to have to go through notice and comment rulemaking under the Administrative Procedure Act, and they're all going to be subject to challenge in various courts, sometimes district courts, sometimes courts of appeal. So that's the process that we're now in. And as I say, it's going to take years, and he'll be gone actually before a lot of these cases are resolved. And who knows what's going to happen after he's out of office and who comes in next. That's another big question mark.
So in an executive order entitled Putting America First in International Environmental Agreements, he withdrew from the Paris Accord for the second time. What's the impact of that?
Well, the impact is to certainly slow down the rate at which countries that are signatory to the climate treaty are upping their commitments. Biden made a very strong commitment to cut our emissions in half. That's not going to happen now, of course, by 2030. I wouldn't overstate this because several countries, in response to what Trump has announced, including China, have said, you know what, we are going to stick with the international process under the Paris Treaty, Paris Agreement. In fact, China is saying we're going to up our game. And we see, as I said this before, we see the economic advantage of building more clean energy and providing more of the rare earth materials that are required for electric vehicles and other green energy, right? So it's going to be a mix. I mean, it's not a good thing, but I don't think it's going to mean that all progress is going to come to a screeching halt by any means. The other thing is, once again, as we saw before, we're going to see states and cities and counties stepping up and doing the best they can anyway to fill some of the gaps. California, the fifth largest economy in the world, has already announced that it's going to make up for the fact that the Trump administration is going to not be building as much charging stations to support electric vehicles. They're going to be putting very significant money into that. They may expand their cap and trade program. Other states are looking to join that program. The state of Washington has adopted a carbon tax, which has been renewed by a popular referendum in Washington state. So Vermont, my little Vermont, has adopted a climate superfund law to go after the oil companies to get money for adaptation. We're going to see those kinds of efforts picking up, at least over the period of time that Trump's in office this time. It won't make up for all of the loss of momentum and opportunity that Trump is going to cost us. It won't make up for that, but it'll offset some of it. And it'll at least keep us fighting for trying to get to the point where we really are seriously reducing the emissions that are causing the kinds of hellscapes that we're seeing in L.A. County right now.
I'm waiting for the first lawsuits to be filed over these environmental orders. We shall see. Thanks so much, Pat. That's Professor Pat Parenteau of the Vermont Law and Graduate School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.